911, where's your emergency?
Welcome back to Topics of Today. I'm your host, Ronald. If you've been following our deep dives into the Centerville Mills Dog Park shooting case out of Geauga County, you know things have been moving pretty fast. In our last episode, we talked about the upcoming Zoom meeting with Judge Paschke. Well, that conference took place, and it resulted in a massive development. We now have the official signed scheduling order setting our roadmap all the way to the jury trial. Let's break this down to what the court has ordered, from the courthouse location to the specific trial rules. To fully understand what's at stake here in the new court dates, we have to go back to that afternoon on April 21st, 2026 at Centerville Mills Park in Bainbridge Township. What started as a regular day at the dog park took a violent turn when an argument broke out over a political debate regarding Donald Trump. According to a witness and police reports, 80-year-old Emmanuel Mike Matthews of South Russell was sitting with a friend reading a newspaper and discussing his support for Donald Trump. Another park visitor, 55-year-old Marine Corps veteran David Matai, overheard this conversation and interjected himself with his own opposing views. From there, accounts drastically diverge. Matai's side claims the argument followed them to their vehicles in the parking lot. Matai stated he noticed a handgun on Matthew's seat and tried to leave, but was shot in the back while trying to secure his dog into the carrier. He suffered several back injuries, requiring immediate life-saving surgery. However, Matthew's defense attorney, Ian Friedman, paints a completely different picture of the incident. The defense claims that Matai was actually the initial physical aggressor, alleging that he went berserk, physically shook Matthews, and grabbed the 80-year-old by his hair. Matthews told arresting officers he fired because he felt his life was in imminent danger as Matai came back towards his vehicle. Notably, police confirmed that Matai was also armed and had fired back at Matthews during the altercation, leaving several bullet holes in Matthews' vehicle. Following a lengthy preliminary hearing in May that established probable cause, a Geauga County grand jury officially indicted Matthews. He is facing a single count of felonious assault, which is a second-degree felony in Ohio, and carries a mandatory firearm specification. If convicted, Matthews could face several years in prison. At his June 10th arraignment, Matthews pleaded not guilty. Because of his age and health requirements, his initial bond conditions were modified. While Matthews remains on GPS monitoring and is under a strict no-contact order with Matai, his house arrest was lifted so he can attend doctor's appointments and complete physical fitness routines prescribed by his physician. This brings us directly to the official scheduling order filed by Judge Paschke. The order commands the prosecutor, the defendant, and trial counsel to physically present at the Geauga County Courthouse located at 100 Short Court Street on the second floor in Chardon, Ohio. For legal teams listening, the courthouse can be reached at 440-279-2190. First up on the docket is the criminal pretrial on Monday, August 10th, 2026 at 1:30. This date is going to be the first major battleground for the defense. Under Ohio's updated Stand Your Ground statutes, individuals no longer have a duty to retreat from a threatening situation before using deadly force, as long as they are in a place they have a lawful right to be. At the pretrial, expect defense attorney Ian Friedman to heavily leverage this framework here. The defense will argue that an 80-year-old man being physically assaulted by a younger man has a reasonable fear of imminent death and or great bodily harm. However, Special Prosecutor Seth Enlow will likely counter that the words alone do not justify deadly force. The court's order explicitly notes that all the issues concerning discovery must be presented at this pretrial and all motions must be filed before it. Interestingly, Judge Paschke made it clear in writing that the court will not participate in plea bargaining discussions. If this case moves forward, the trial management conference is scheduled for Thursday, September 10th, 2026, 1:30 p.m. Judge Paschke is running a tight ship because most things here to note, counsel must be prepared to report the names of all witnesses, the exhibits expected to be offered, and any stipulations, proposed jury instructions that have to be formatted in MS Word, and the anticipated duration of the trial. If no resolutions happens there, the final countdown begins in October. Trial preparation is set for Monday, October 26, 2026 at 1:30 p.m. The formal criminal jury trial kicks off the next morning, Tuesday, October 27th, 2026 at 8 a.m. sharp. The order outlines strict trial rules. Counsel must check in with the bailiff at 8 a.m. The final list of exhibits and witnesses alongside pretrial motions, like motions in limine, must be submitted to the court at least 7 days before the trial. Pay close attention here. The judge has detailed specific consequences if the legal teams fail to prepare properly. All documents and exhibits must be pre-marked for identification purposes and shared with opposing counsel before the trial starts. The state of Ohio must mark theirs using numbers, and the defendant's team must use letters. The penalty for failing to do this is severe. Any documents or exhibits not properly marked and shared may be barred from being admitted into evidence entirely, which could easily break the team's strategy. If either side wants to use the courtroom monitor to display evidence, they are responsible for bringing their own laptop with HDMI connection or adapter and managing that equipment themselves. Even the juror questionnaires will only be available for review, but not copying, exactly 1 day prior to the trial in the court's reporter's office. The legal teams needing to schedule a time to look at those questionnaires must contact the court reporter, Beverly Modick, directly at 440-279-2194. Finally, do not expect a delayed trial. Judge Paschke ruled that no continuance will be granted except for good cause shown in writing. Furthermore, the order does dictate that all requests for continuances must strictly comply with the Common Pleas Superintendence Rule number 41. Now, for all those non-lawyers out there, and I know there are plenty of them, Rule 41 is the Ohio Supreme Rule that handles conflicts when an attorney has multiple trial assignments overlapping on the same day. It dictates which court takes priority, usually based on whether it's a criminal case, a designated complex litigation case, or simply whichever case was scheduled first. Under Rule 41, an attorney can't just miss a trial because they are busy in another courtroom. They have to file a formal application that names a conflict case, provide the date it was set, and attaches a proposed order of the court for the judge to sign. The judge made it clear if a continuance is actually granted, counsel must immediately adjust all of their deadlines for filing trial management reports, depositions, and pretrial motions to match the new timeline. Now, if this dog park case feels unprecedented, it actually fits right into a massive historical and structural shift in Ohio's self-defense landscape. For decades, Ohio was the only state in the country where a defendant who had claimed self-defense bore the burden of proving it to a jury. That all changed with a monumental legislative overhaul in March of 2019, which shifted the burden entirely to the prosecution. Under this framework, a defendant only needs to show a baseline of evidence that tends to support self-defense. Once they do, the state has to prove beyond a reasonable doubt that the defendant was not acting in self-defense. Then, in April 2021, Senate Bill 175 went into effect, removing the duty to retreat anywhere a person is lawfully allowed to be, officially rendering Ohio a stand-your-ground state. We've seen recent local cases highlight just how difficult this makes securing convictions for the prosecution. Just look at the Montgomery County trials of William Pointer and Anthony Perkins. In both instances, defendants were acquitted by juries after raising self-defense claims because the prosecution simply didn't overcome the defendant's narrative without definitive outside evidence. But prosecutors still have a path to victory. Take the case of the 71-year-old Vietnam veteran Richard Palmer in Claremont County. Like Matthews, Palmer claimed self-defense during a confrontation at a gas station. However, the judge ruled that Palmer's self-defense claim wasn't credible because Palmer had aggressively followed the victim, effectively creating the violent situation himself. The judge blocked the jury from even considering self-defense, and Palmer was convicted of felonious assault. That is exactly the historical precedent the prosecution will try to use against Matthews. If the state can prove Matthews escalated the situation into a deadly force or was just the primary aggressor in the parking lot, his stand-your-ground protections could vanish. With the trial clock officially ticking, both sides just have over 3 months to solidify their narratives before a Geauga County jury. It's a case that forces us to look at the intersections of extreme political polarization, gun safety, and real-world boundaries of self-defense laws. We will continue to watch the second floor of the Chardon Courthouse very closely. That's all for this expanded update episode of Topics of Today. Make sure you hit that subscribe button on rss.com or your favorite podcast app so you never miss a development. I'm Ronald, and I'll catch you on the next episode.